Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. The Honorable Justice Hennessy presiding. Long live the King. You may be seated. Dr. Driben, you remain under oath from yesterday.
I understand that, yes.
Thank you.
Good morning.
Good morning.
Good morning.
So before we start today, Canada wants to state their position on Mr. Schachter's question about the white sand and red rock existence question.
Okay, could you give me 1 second to connect in, please? Go ahead.
So Canada's position is that whether the bans existed in 1850 is a complex issue that does not need to be resolved for this proceeding, since Canada does not dispute that white sand and red rock are entitled to share in any compensation awarded in this litigation. In response to Mr. Schachter's concern that Canada might take the position that any award should.
I'm just going to say, Ms. Sang, if you're reading something, you often read faster than just the rate at which you speak.
Okay.
So let's start at the beginning. Canada does not,
We
you don't dispute that white rock and
white sand and red.
white sand and red rock are entitled to share in whatever is awarded to the plaintiffs.
That's correct.
They are the plaintiffs.
Yes.
They're entitled to make a claim. They're entitled to.
Well, in response to his question, Canada does not take the position that any compensation that's to be divided among the bands who existed in 1850, Canada does not take that position.
There might have been a double negative there that I missed the meaning of it.
So
Try that again.
yesterday, he said that he was concerned that Canada might take the position that any compensation would only be divided among the bands who existed in 1850.
Yes.
And we just want to say that we are not taking that position and will not be taking that position.
Okay.
And so
So go backwards. What position are you taking?
we are taking the position that whether the bans existed in 1850 is an issue that we do not need to be, that does not need to be resolved in this proceeding.
Whether the two named bands.
Correct.
All right.
We also just wanted to say that we do not dispute that they are legitimate plaintiffs and are entitled to any share of compensation, potentially going back to 1850. And that's all we wanted to state for the record.
You take the position, you do not dispute that White Sand and Red Rock are legitimate plaintiffs
Correct.
and entitled to share.
And any compensation awarded.
Okay. Anything else?
No, we just wanted to state that.
Okay. And can I get that first proposition about the complicated question? What do you say is the complicated question?
Whether or not white sand and red rock were in existence in 1850.
And it's a complicated question. do you say it has particular consequences and that's why you don't want to take a position on it?
Well, as Dr. Driben pointed out in his report, no one knows precisely how many separate and distinct bands belonged in the Nipigon band. So it's still a point of contention. And for the purposes of this litigation, we do not think it needs to be resolved.
And, but you're either not telling me or you don't know what the consequences are of taking a position. Like you're not saying you're afraid of this finding or this position for some particular reason,
No, at this point, we are not expressing any concerns.
or telling me what your concerns are.
We do
You
not.
say you don't have concerns, you're just not taking a position.
We are not.
So, okay, thank you. Mr. Schachter was on his feet.
Yeah, the issue of whether they existed in 1850 is not complicated and is relevant. And a third aspect, my friend's response that you don't need to decide that issue still doesn't address the other issue of, you might remember that all the plaintiffs and potential plaintiffs have agreed to how to divide up the pie, so to speak, if there is an award. Canada and Ontario have not agreed to that. And so I don't know if my friend means to say that they now agree, and I don't know if I'm pressing my friend, but I think that's an important issue, that if they agree on the division that's been agreed to by the plaintiffs, that would be nice to know if that's what we're trying to understand here.
So
Right, just, can you remind me, is that agreement amongst the plaintiffs with respect to division before the court, is it in the order?
Yes, it is in the intervention
In the
orders.
intervention order,
Both of
okay.
them.
Both,
Group of seven
both the
and
group of seven and
the group of three amended claim
the group-
representation order.
yeah,
Okay.
so it is before the court. And Ontario and Canada, I believe, insisted at the time that they wanted to reserve the right to take a different view on allocation. So, the issue is still technically alive, I suppose. And if my friend was trying to advise the court that that's no longer an issue, that would be great. If it is, you've got Dr. Driben's evidence on White Sand and Red Rock and the other evidence he's provided by way of his reports. And I will make argument about proper allocation if they don't concede it.
Okay, thank you.
So in response to that, Canada has not agreed to the distribution at this point.
To the sharing agreement set out in the orders.
Correct.
And do you see a problem with not taking a position and leaving that open? Do you tend to lead evidence contrary to that?
At this point, I cannot give the court an answer, but once Ms. Evans is back, hopefully we can advise the court.
Okay. Well, I'm going to ask, I presume that is our next attendance. You're expecting Ms. Evans to be back?
Yes, we do.
I think it's in a couple of weeks.
That's correct.
All right. So I'll be wanting that answer. Okay, thank you. Mr. Schachter's on his feet.
Yes, just one more matter. Just before court, my friend had indicated that she was going to be advising the court, I thought, perhaps I misunderstood, about Canada's position on population. Just spoken before court, did I misunderstand? Wanted to address the court on population issues?
At this time, Canada's position is that we have the 2018 figures and that's what we will be using.
Oh, okay. I did misunderstand. I'm sorry.
Just going,
So did you say 2018 figures? Thank you.
I just might need Helen's. One moment, Mr. Rankin. Finally, Mr. Rankin, when you're ready.
Good morning, Your Honor.
Good morning.
Good morning, Dr. Driben.
Good morning.
So Dr. Driben, you'll remember that where we left off yesterday, we were talking about sharing, correct?
Yes,
So what I'd like to do now is to revisit some of your testimony from the stage 1 trial regarding sharing, okay?
sure.
So if we could start at tab 10 of Exhibit K, please. K, yes, as in K. Or at tab 10, Your Honor.
Got it.
So Dr. Driben, this is a transcript of your evidence from October 4th, 2017. And I believe you have had the opportunity to review the transcripts of your evidence from the stage 1 trial recently. Is that correct?
That's correct. Yes,
Okay. And do you remember testifying in this court in Thunder Bay on October 4th, 2017?
yes, I do.
So, Dr. Driben, I'd like to jump in to page 746 of the transcript, which is on the second page of this tab. And I'm going to start on line 7. You see that?
I do. Yes,
Okay, so question, and that amount can increase up to $4. Answer, no, 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 I'm sorry, maybe I'm not being clear. There is a ceded territory. There is revenue from the ceded territory. That ceded territory 1 year might yield $1 million. The next year, it might yield $10 million. If it yields $10 million, the Anishinaabe will receive more. Question, how much more? Will they receive all of it? Answer, a share, not all of it, not all of it. The Anishinaabe are not. They're not trying to capture all of the wealth. They want to share the wealth. So they're not saying all of it. They have to determine the value to get their share of what's coming. I don't know what that share would be. I don't know whether it would be 50% or 80% or 30%. I would imagine that would be up to the future to decide. And I'm going to pause right there for a second, Dr. Driben. So do I understand that your evidence is that as an ethnohistorian, you cannot tell us what the percentage share should be under the augmentation clause, correct?
that's correct. You'd have to consult with an economist, like previous witnesses, Dr. Stiglitz, to determine figures like that. I cannot determine the share in terms of percentage or anything like that.
So that's not something you can help us with.
No, I'm sorry, I can't.
So I'm going to keep going where the highlighting switches to light blue. Do you see that at line 4, Dr. Driben?
Yes,
Once you have calculations, once you have a database, you can use to say, oh, this is reporting back to you. There's so much revenue from the ceded territory, how much? Then you decide on the distribution. And that distribution, I believe, would be based on the, at least as far as the Crown was concerned, as far as regulating the amount payable to the individuals out of that larger amount beyond the $4, that would be up to the Crown to have a say in. That would not be up to the First Nations to decide whether they wanted whether they wanted to take some portion of the collective annuity and increase the amount payable to individuals. Question, sorry, did you just say that? I'm just going to repeat this back, that the First Nations do not decide the share of the wealth that they will receive. Answer, nobody has decided the share here. The share has not been decided. Over on the next page, question, at treaty time, you're talking about? Answer, yes. So Dr. Driben, do I understand you to be saying that in 1850, the treaty partners had not decided what the share would be?
That's correct. They had to determine the value of the ceded territory before they determined the share. And Potoshat was asking for that, and as well, Vidal and Anderson said that the value of the land had yet to be determined. The value of the potential ceded territory had yet to be determined. And then in the petition, the 1884 petition that we read yesterday, again, the question was the value had not been determined yet. So when the value would be determined, then the share could be determined.
So in 1850, there wasn't an agreement on the share.
There was an agreement on sharing, but there wasn't an agreement on percentage of share.
So Dr. Driben, I'm going to keep going with the highlighting switches to green
Yes,
at line 4. Do you see that?
I do.
Question, I understand. What about going forward? Who do they understand will decide about a proportion of the share of the wealth? Answer, Anishinaabe would certainly say they have a right to participate in that discussion, but I imagine that the Crown would say the same thing. So I imagine this would be a mutual endeavor where they would try and determine the amount, the share, where the money should be, cash might be invested, you know. But this would be in the future, and this would be up to the parties to the agreement to discuss. They couldn't discuss it at the moment, I believe. That is to say, the Anishinaabe and the Treaty Commissioner, because no value had been determined at that point. Question, but they could have discussed principles with respect to who would be responsible for determining the share of the wealth. Was that not discussed? Answer, principles for determining the share, I don't know. I see no evidence that that was discussed. Whether there would be, well, the principles, pardon me, yes, there would be a principle. The principle would be that the more the ceded territory yielded, the more the Anishinaabe would receive as their share. That would be the principle. And that's a principle that they could understand. The more you get, the more I will get. You see that?
I do see that. Yes, sir.
So I understand, Dr. Driben, that you're saying that determining the share in the future would be a mutual endeavor as between the First Nations and the Crown, correct?
Well, it would have been at the beginning if a value had been determined, but as time has passed now, we can see that that decision about the share is in this courtroom.
So Dr. Driben, you'd agree with me then that it's not that under the treaty, the Anishinaabe would determine for themselves the amount of share that they would receive, correct?
Correct. This is a relationship between the two partners to the agreement. They both agree to share. They both agree to share on the basis of their understanding of their relationship with one another, which is a kinship relationship, a generous relationship. But since no value has yet been determined for the ceded territory, as I said, one cannot determine the share.
Okay, Dr. Driben, I'd like to turn to the diversity of views among the various chiefs who attended the Treaty Council in 1850, okay?
Certainly.
So your happiness report, Dr. Driben, discusses Chief Shimwakans, correct?
Yes, it does.
And Chief Shimwakans was from Garden River, correct?
That's correct.
Garden River is on the Lake Huron side.
Yes.
And you'd agree with me, Dr. Driben, that Potoshat and Shimwakans did not see eye to eye on all matters during the treaty negotiations in 1850?
I would agree with that. Yeah, they didn't agree completely. Yes.
So just as an example of that, perhaps hours after Potoshaw said that the amount made no difference to him, which we discussed yesterday,
Yeah.
Shimwakon's reiterated his proposal for $10, correct?
$10 for the individual portion, the individual portion of the collective annuity. The collective annuity already had been agreed to with both parties. So what Shinglecon's was arguing for was he wasn't saying the same as Potoshat. Whatever it is, you decide for, we're ready to go ahead. He says, no, he says, oh, I want the individual portion that's coming to the individuals to be $10. That's what he's saying there.
Okay, so, but you'd agree with me that Anishinaabe leaders in the 19th century could hold differing views with respect to an appropriate annuity under a treaty, correct?
Yes, it's important to understand here that the Ogama Gigido, the spokesperson for the group, will represent the group, the consensus among the group. So they do speak with one voice with regard to that group. So in this case, Potoshat is the Ogama Gigido for the Lake Superior delegates, and Shingawakons is the delegate is the Ogama Gigido for the Lake Huron delegates. The Lake Huron delegates will agree, although there's some disagreement among them, but they will agree, and the Ogama Gigido will represent their opinion. And on the Lake Superior side, likewise, there'll be a consensus, and then they'll move forward. There'll be a consensus among the delegates, and then they will move forward.
So Dr. Driben, there's a possibility of differing views by the Ogama Gigido of Superior versus the Huron side, correct?
Yes,
So you'd agree with me that the shared culture of Anishinaabe leaders did not dictate a precise formula for a treaty or an augmentation clause?
I'm sorry, I don't quite grasp the question.
So Dr. Driben, you'd agree with me that Potoshaw and Shimwakons had a shared culture, correct?
Yes,
And you'd agree with me that that shared culture did not dictate a precise formula for an augmentation clause under a treaty, correct?
no, the fact that they had a shared culture doesn't dictate the terms of the augmentation clause.
And Dr. Driben, you're aware that some Anishinaabe treaties from the 19th century involved lump sum payments as opposed to annuities, correct?
That's correct. Yes, I'm aware of that.
So Dr. Driben, I want to turn back to your evidence from the stage 1 trial. And for that, if you could turn with me to tab 11 of Exhibit K.
I'm there.
So this is page 750 of your testimony on October 4th, 2017. And I'm going to start on line 18. Do you see that?
I do. Thank you.
Question. So if I understand you, what you're saying is the parties understood at treaty time that initially the Crown would determine the share of the revenues that should go to the First Nation signatories from the ceded territory. Answer, Potoshaw agreed. I'm really hope I can answer this question properly. Potoshaw agreed that it would be up to the Crown to determine the share of the revenue from the ceded territory that the First Nation, that Fort William First Nation, that others would receive. Question, under the augmented annuities clause. Answer, under the augmented annuities clause. And I also want to say that he expected the share to be a generous one. That's why he said, we trust you. Question, and did other Indigenous signatories to the treaties have that understanding as well? Answer, that I believe they had the understanding, all the Indigenous signatories understood that when the revenue from the ceded territory, as it increased, that their revenue, the band's revenue, the revenue to the band, the collective would increase. This was, the chiefs in 1851 said, this we're glad to know, as you told us, when you sell our land, we will get more. That's the kind of understanding they had. Question, so my question though, was about the share and who determines the share. You suggested that Podesha believed the share will be determined in the early days by the Crown. Answer, yeah. Question, what about the rest of the Indigenous people? Answer, I'm not sure about the Lake Huron side. Question, what about the rest of the Lake Superior? Answer, yes, yes. Because Podesha was Ogima-Gijido, he was speaking on behalf of the whole. Question, you're not sure whether that applied to the Lake Huron? Answer, I haven't really, no, I'm not sure. So you weren't sure about the Lake Huron side of the lodge, correct?
About who would determine the initial share?
Correct.
Correct, yes. That's what I've said here.
And you weren't sure about Lake Huron because Podesha and Shinwakons did not necessarily have the same views on sharing, correct?
Well, they understood the augmented annuity, both understood the augmented annuity, but the question of sharing again depended on the value of the territory ceded. So that would be impossible to determine without knowledge of the value. That had yet to be determined.
But Dr. Driben, my question was, Podesha and Shinwakons did not necessarily have the same views on sharing, correct?
Well, in general, they did have the same views on sharing in the sense that they are a sharing culture. But if you're talking about the disposition or the allocation of the annuity afterwards, is that what you're asking about?
So perhaps I can rephrase the question, Dr. Driben. So Podesha and Shinwakons did not necessarily have the same views on how sharing would translate into an augmentation clause under the treaty, correct?
I think they both understood that it would be generous. Yeah. So I think in that sense, they had agreement for sure. And they understood that the Crown would share the revenue from the ceded territory. And they also understood that they would use the wherewithal that they received to revitalize their culture and thrive as people. They both understood all of that about the share. I think they held those things in common.
Okay. I'm going to move on. So, Dr. Driben, the transcript at this point now shifts into the Crown understanding. So William Robinson's understanding. So I want to turn there next at tab 12 of Exhibit K. So you'll see that this is actually the same page we were just looking at, 752, with a different section highlighted. And you see that the highlighting starts at line 17, correct?
I see that, sir.
Question, is that what Robinson would have understood as well with respect to the share, that the Crown would have been the one to determine the share to be distributed? Answer, I'm not sure. I'm not sure about that.
May I rise on an objection?
Yes, sir.
This is an objection on relevancy because the decision of phase one as amended by the Court of Appeal addresses this at paragraph 1B. To fulfill the obligation, the Crown is required to periodically engage in a process in consultation with the First Nation treaty parties. That is already a matter that is subject, I guess, to the Supreme Court of Canada, a matter that's res judicata, I would think, before this court, is it not? And if the question that my friend is asking about whether there would be consultation or not, that's been decided by judicial order, I would think. So I don't understand how this question could be relevant.
All right, thank you. And that's because, sir, you're interpreting this question as whether, because I understood the question to be what Robinson thought or
Oh, I
understood.
see. So it might be narrower than I had thought. All right,
I'm not sure.
right, okay. Perhaps it was an improper objection,
Okay,
but maybe we should see where he's going.
all right.
Thank-
And that is my question, sir. Where are we going with this?
Yes, Your Honor, and I might just point out, I hadn't actually asked my question yet, so, but I can tell you where we're going. So I'm going to take Dr. Driben to this passage regarding Robinson's understanding, and then I'm going to take him to a passage in his happiness report where he talks about the Crown understanding. And I want to understand the relationship between those two passages.
All right.
So it's grounded in in Dr. Driben's happiness report.
All right, but you're trying to, you're seeking answers with respect to this witness's understanding of Robinson's understanding.
Correct.
But that is for what purpose? Going in what direction? Because we have a finding already with respect to the interpretation of the clause.
Correct, Your Honor. But now we're into the question of how does sharing work under that clause where there isn't a finding? Right, so
Okay.
my friend was addressing the consultation which happens under the clause. I'm not challenging. That is, I agree with my friend that is a finding, right?
Right.
But that's not where I'm going.
Okay,
It goes to a statement that Dr. Driben makes about the Crown understanding with respect to share in his happiness report,
okay,
which I don't understand to be res judicata.
all right, let's try it.
So Dr. Driben, I'm going to start reading through this passage again, just so we have it all together.
Thank you.
And
So
sorry, we're at
line
tab-
17.
12, line 17, thank you.
Question, is that what Robinson would have understood as well with respect to the share? That the Crown would have been the one to determine the share to be distributed? Answer, I'm not sure. I'm not sure about that. He may have wanted to do that in consultation with the First Nations. He was familiar with First Nations. I cannot answer that question. Do you see that?
I do.
Do you remember saying that?
No,
But you have no reason to dispute that you said that.
no reason to dispute it.
Okay, so as I indicated, I wanted to take you to a passage from your happiness report, Dr. Driben. And this is at the next tab 13.
I'm there. Thank you.
Now, Dr. Driben, you see that this is page 8 again of your happiness report,
Yes,
and that is where you summarized your opinions, correct?
that is correct.
Okay, so I'm going to read to you numbered paragraph 4. And again, I'm going to do it the same way I did yesterday, where I start with "it is my opinion."
I understand.
It is my opinion that the Crown officials with whom the Anishinaabe interacted during the treaty-making process understood that the Anishinaabe held these views and acted accordingly. Do you see that?
I do.
And when you say these views, you mean the 3 numbered paragraphs before, numbered paragraph 4, correct?
Correct.
And we looked at those paragraphs yesterday, and those paragraphs are your opinions on sharing in summary form.
That's correct.
So you're saying that the Crown officials understood that these perspectives on sharing formed part of the Anishinaabe expectation.
Yes, yes,
And when you say Crown officials here, you're including William Robinson.
I am.
Now, Dr. Driben, do I understand that your evidence from 2017 was that you weren't sure about William Robinson's understanding about sharing?
Well, I answered it that way, but I would say that, I would say, given my knowledge then, I would say much the same as I said now. And that's that he understood he understood the Anishinaabe way of life, and he understood the principles of sharing. So that's why I mentioned here that the consultation.
Would it be fair to say that your views today are based on further research you've done?
I would say they're expanded. Yes, certainly. They're not different from my views before, but they're more fulsomely developed.
So you weren't fully sure about William Robinson's understanding before, but you've done further research and now you have a stronger opinion on the point.
It wasn't necessarily William Robinson's understanding. It was the understanding of Crown officials, of the Crown and the relationship between the parties, the circumstances under which the agreement was made. This report is not about the augmented annuity. This is about what happens about sharing, so that there's a different emphasis here, a different emphasis, because new questions have been raised, and I'm trying to answer those questions to assist the court.
Oh, I see. So do I understand then that this numbered paragraph 4, this is simply saying that Crown officials would have understood the Anishinaabe perspective on sharing, not necessarily their understanding of the augmentation clause?
Oh, Crown officials understood, Robinson certainly understood the augmentation clause because he said so. He wrote that the augmentation clause was the key to arriving at the treaty, was arriving at a successful conclusion of the treaty. That was the augmentation clause. So he certainly understood it. Whether others understood the augmentation clause subsequently is an open question. I think because if others understood the augmentation clause clearly, then it seems to me that the value would have been determined sometime in the future.
So Dr. Driben, at the end of this paragraph 4 that we looked at, you have a reference to an article by Professor Stark titled "Respect, Responsibility, and Renewal: The Foundations of Anishinaabe Treaty Making with the United States and Canada." Do you see that?
I do.
And I believe it to be the case that this is this reflects further research that you've done into the question about the Crown officials' understanding.
Well, it's my understanding of the nature of the treaty-making process in general among Anishinaabe people, which is what Dr. Stark is writing about here in this paper.
All right, so I'd like to actually turn up that article, Dr. Driben, and this is the next tab, tab 14.
Yes,
And Your Honor, this is already in the joint book of documents. It's exhibit 1-1661.
Okay.
And Dr. Driben, this is among the list of materials that we asked you to review in advance of your cross-examination, correct?
that's correct.
And you had a chance to review it?
I have.
And would you agree with me, Dr. Driben, that Dr. Stark speaks generally about the Crown's understanding of Anishinaabe culture, correct?
Yes, yes.
But Dr. Stark doesn't say anything about William Robinson, correct?
That's correct.
And Dr. Stark doesn't say anything about the Robinson treaties, correct?
That's correct. If I recall the article correctly, yeah.
I'm going to move on to a new topic. And that is the historical Anishinaabe perspectives on economic concepts, okay?
Certainly.
So, Dr. Driben, if you could turn with me to tab 15 of Exhibit K, you would see that this is page 15 from your happiness report. Do you recognize it?
I do, sir.
And do you see that in the middle of the page, there's a heading that says economic terms.
Yes, sir.
Now, if I could just summarize my understanding of this section, Dr. Driben. You're writing here that the Anishinaabe relied on their own values, not the cost of production, to determine how much they wanted in exchange for products, correct?
And yes, and in the fur trade, certainly, costs of production, there was no way to determine costs of production because there was no standard of value, say for like currency, there was no currency. It was based on social considerations.
So the Anishinaabe worldview in the 19th century would not have included concepts like the cost of production, correct?
No, it's, as I said in the report, they're not part of the economic lexicon of the Anishinaabe at that time. If we want to understand the sophistication of their economic understanding, then we have to look at terms that deal with hunting, trapping, fishing, berry picking, collecting, trading. And in those cases, we'll see that we do have a well-developed lexicon in Anishinaabemoan, the language of the people.
So trade would have been based on Anishinaabe values and custom, not the cost of production and economic concepts, correct?
That's quite true. And the people who traded with the Anishinaabe understood that that was the case because the traders quickly found out that if, well, for instance, if there were no kinship relationship to begin the transactional relationship, there would not be trade at all. So they adopted Anishinaabe principles to engage in trade. Let me say, the Europeans adopted Anishinaabe principles to engage in trade with them because that was the only way they could engage in trade with them. And the Europeans wanted to engage in trade.
Okay, so the trade based on Anishinaabe values and customs, this wouldn't be based on concepts like economic surplus, correct?
Not as far as I understand that term as a layperson.
That's fair, Dr. Driben. Now, Dr. Driben, do you remember testifying at stage 1 that the Anishinaabe in the mid-19th century were not interested in accumulating wealth?
That's correct.
So I'd like to drill in on that, Dr. Driben. So if we could turn to tab 16 of Exhibit K. And this is, again, a transcript from your examination in October 2017. This time it's October 2nd, 2017, so a couple of days before the section we looked at before. And you had a chance, I take it, Dr. Driben, to take a look at your transcript from October 2nd, 2017 as well.
Yes.
So on page 305, under this tab, do you see at line 17, it says the witness, the proposed amounts of money? You see that?
I do see that.
Yeah, and you'd agree with me that the witness referred to here is yourself?
Yes.
And before I read this, Dr. Driben, this is a portion of your transcript where you're talking about your opinion that the Anishinaabe in 1850 did not understand the concepts of money.
That's correct. They did not understand the concept of money. They did not have money. They did not use money, except as a trade good on rare occasions.
So that remains your opinion then, that the Anishinaabe did not understand the concept of money in 1850.
The Lake Superior Anishinaabe, certainly, yes.
So I'm going to read, starting at line 17. The witness, the proposed amounts of money when Shinwakans, let's say, is demanding $10. The Lake Superior chiefs say, we trust you. We will accept, we regard you as our great mother and our great father. When Shinwakans is talking about the $10, what he is talking about is what he is aware of other where other treaties have been made in Southern Ontario. He is aware other treaties have been made in the United States. He is aware that Indians get paid for that. He is aware in Southern Ontario, the payment is $10, and therefore he says $10. But $10 to him is not $10 to me, because their economy is still a gift-giving economy. It's still functioning on gift giving. They're not interested in accumulating wealth. When you don't accumulate wealth, money is not of interest. Unless you have a need for a standard of value and a means of accumulating wealth, you don't have money, and they didn't have money. Do you see that?
I do see that.
So you remain of the opinion that the Lake Superior Anishinaabe in the mid-19th century were not interested in accumulating wealth, correct?
That's correct. That was not the nature of their economy. Their economy was an economy of sharing, so that generosity was the ideal in the economy.
Dr. Driben, you've done quite a bit of work with respect to other treaties in Canada and the United States, correct?
Correct.
And that includes testifying in US courts regarding treaties between the Anishinaabe and the US government, correct?
That's correct.
And you speak about US treaties in your happiness report.
That's correct.
And some of the US treaties that you discuss in the happiness report involved annuity payments for time-limited periods, such as 20 years.
Yes, that's correct.
And some of those annuity payments were fairly substantial amounts of money, correct?
As a lump sum, yes, they were.
Dr. Driben, are you aware of any situations where the Anishinaabe in the mid-19th century were investing annuity payments in the stock market?
I really don't know the history of the stock market. I can't answer the question. I don't know whether there was a stock market at that time, as I understand the stock market.
Okay, but that's not something that's come across in your research into Canadian or US treaties, correct?
No, I have come across, statements by Anishinaabe leaders at the end of or towards the period where a fixed annuity, let's say over 25 years, is about to run out. And when that happens, depending upon the treaty itself, then the Anishinaabe would ask not just for the principal, but they would ask for interest as well on it, the growth on that.
So I'm turning, Dr. Driben, to my final topic, which is Minnow-Bemadzewin.
Yes.
And Your Honor, I'm doing quite well on time, and I see that it's coming up on 11:20. I'm happy to keep going, or I'm happy to take a break. as
Why don't we
the board-
take a break if you're going to start a new section? Is
Sounds good.
that all right?
Thank you, Your Honor.
Okay. 15.
This court will recess for 15 minutes, resuming at 11:38. Thank you. This court is now resumed. You may be seated.
When you're ready.
Dr. Driben, I indicated just before the break that we would be picking up with Minnow-Bemadzewin.
Minnow-Bemadzewin, yes, sir.
So if we could go into tab 17 of Exhibit K.
I'm there, sir.
And you recognize that in this tab, we have page 19 from your happiness report.
Yes.
I'm going to read to you the second paragraph on page 19. And the fifth, let me just pause there. the fifth, it's your fifth opinion, right?
That's correct.
So, and the fifth is that the Anishinaabe intended to use the share they would receive under the auspices of the quote augmentation clause, end quote, to help them achieve the life that mid-19th century Anishinaabe aspired to follow. Anishinaabe called it Minobamadzewin, quote, the way of a good life, end quote, which is to say, experiencing life in its fullest sense, based on a personal foundation of emotional, physical, mental, and spiritual health, which are the four aspects of the self in Indigenous thought, and an abiding concern for the individual and collective welfare of all living things. Do you see that?
I do.
So you're saying, Dr. Driben, that Minobamadzewin is based on a foundation of the four aspects of self in Indigenous thought, correct?
Yes,
And those four aspects are the emotional, physical, and mental health of the individual?
and spiritual health of the individual as well.
Thank you. Your report discusses how the quest for Minobamadzewin requires adequate material resources to be acquired, correct?
Yes,
Okay. I'd like to talk about that. So if we could turn over to page 83 under the same tab, still of your happiness report.
yes.
And I'm going to read to you the second paragraph. Two additional points about the quest for Minobamadzewin deserve mention. The first is that the emotional, physical, mental, and spiritual health that is acquired during the quest for Minobamadzewin requires adequate material resources to be acquired. Otherwise, those seeking Minobamadzewin almost certainly will be distracted by subsistence demands that will truncate or delay the process. In my opinion, this was one of the reasons the Lake Superior and Lake Huron and Anishinaabe agreed to collective annuities, which they thought would help them overcome the economic challenges they were facing at the time and hasten the return to, quote, the way of a good life, end quote. So while money per se was not the issue, material resources were in play. Do you see that?
I do.
So basically, Dr. Driben, money doesn't buy Minobamadzewin, but money can supply material resources which support the quest for Minobamadzewin, correct?
Yes, material resources are necessary to acquire Minobamadzewin because Minobamadzewin is not an aesthetic exercise where you remove yourself from society for contemplation purposes. This is an active philosophy. You participate with others in the world, human persons and non-human persons. And one of the dictates, if you look at the teachings of the seven grandfathers, underlying those is, or involved in all of them, is generosity. For instance, love, generosity, wisdom, being generous. All of them have elements of generosity in it. Being generous in Anishinaabe society means giving. And so to properly be on the red road, to be on the tobacco road, you must share. And material resources are part of that sharing. Another part is sharing knowledge.
Now, Dr. Driben, in the passage I just read to you from page 83, you used the phrase subsistence demands. Do you see that? It's about halfway down the paragraph.
Yes,
And by subsistence demands, do I take you to mean day-to-day needs?
I meant that I meant subsistence demands here in terms of the 1850 lifestyle.
And that would be day-to-day needs in the 1850 lifestyle, is that right?
It would be day to day, it would be living off the land in 1850, but taking into account the problems that they were facing at the time. As I said yesterday, the economic problems and the social problems they were facing. So given those problems, material resources are necessary for them to be on the tobacco road at that time. And that's the message I get from them quite clearly. They want to be on the tobacco road. This is the life to which Anishinaabe aspire. It's not something that only lived in 1850. It is the life to which Anishinaabe aspire today. People want to be on the tobacco road because that's what brings you happiness, and happiness isn't even the right word for it. It makes you fulfilled as a human being. You understand your purpose on this planet. This is why I'm here. This is why I've been created.
Can I put it this way, Dr. Driben, that if day-to-day needs aren't being satisfied, then the quest for Minnow-Bemadzewin will be delayed or truncated?
Oh, certainly. If today, say, for instance, there's disparities, say, for instance, in rates of sexual assault, education levels, income levels, and any number of the problems that the Court of Appeal identified, plus the ones that I added in my essay in the CODA, if you have these problems in your communities, Minnow-Bemadzewin will be extremely difficult, as far as I see it, and understand it to achieve, because you just can't do it. You just won't be able to do it. That's a real problem, because the idea of achieving Minnow-Bemadzewin is still there, and it's frustrating if you can't get on the tobacco road. It can be very disappointing to people, because that's the goal of life.
Okay, Dr. Driben, I want to turn to the part of your happiness report where you talk about a concept of a moderate livelihood.
Yes.
And I believe what you're saying, if I could summarize it, is that the augmentation clause was about something beyond a moderate livelihood. Is that a fair summary of what you're saying?
I think so. I put it this way. I would say that there was no real discussion about the Anishinaabe subsistence at that time, because Treaty Commissioner Robinson told the Anishinaabe, in effect, that he wouldn't interfere with their foraging activities, which is to say living off the land activities, hunting, trapping, fishing, and collecting. I'm sorry. I was really going there.
Ouch.
Okay, take a breath.
Thank you.
The issue of subsistence was not a topic of serious discussion during the treaty negotiations in 1850. It was a different situation than with the Mi'kmaq.
Okay, so, and I want to talk about the Mi'kmaq case that you discussed in your happiness report, actually. So in your happiness report, where you talk about moderate livelihood, you discuss a decision from the Supreme Court of Canada called the Queen and a Marshal. Is that right?
That's correct.
And that case was about the Mi'kmaq nations in Nova Scotia, correct?
That's correct.
Now, I don't want to get into a legal interpretation of the case with you, but I do want to take you to what you say about this case in your happiness report, because I have some questions which follow from your comments.
Sure.
So if we could go, Dr. Driben, to tab 18 of Exhibit K.
I am there.
And this is page 74 from your happiness report.
Yes, it is.
Now I'm going to read to you from the second paragraph, which starts the clash between.
Yes.
The clash between the lobstermen can be traced to a 1999 Supreme Court of Canada decision in which Justice Ian Binney, writing for the majority, concluded that a 1760 treaty between the Crown and the Mi'kmaq, quote, affirmed the right of the Mi'kmaq people to continue to provide for their own sustenance by taking the products of their hunting, fishing, and gathering activities and trading for what in 1760 was termed, quote, necessaries, end quote, and then larger quote. Mr. Justice Binney also wrote that the modern equivalent of this type of foraging gave the Mi'kmaq the right to generate a, quote, moderate livelihood from their Aboriginal homeland, as opposed to the, quote, open-ended accumulation of wealth. You see that?
I do.
And in that passage I just read to you, you're referring to the Queen and Marshal, correct?
Yes,
And you cite the Queen and Marshal at footnotes 206 and 207, correct?
yes,
And you quote from the Marshall decision in that passage I just read to you,
yes,
and you've read the Marshall decision?
yes, I did.
And in fact, that was one of the documents we asked you to look at in advance of your cross-examination
Correct.
today, correct?
Yeah.
So I want to turn into that decision, which is at tab 19 of Exhibit K.
Sure.
And Your Honor, this has already been marked as an exhibit. It's Exhibit 1-1551.
Thank you.
Now, the part I'd like to land on, Dr. Driben, is paragraph 59. And I have to apologize, the pages are not numbered, only the paragraphs.
But if you flip through looking for highlighting, you'll find it.
That helps as well, Your Honor.
Oh, I'm at paragraph 20, 59?
59, yes.
I'm
Dr. Driben.
sorry. Yes,
So I'm going to read paragraph 59 from the Marshall decision. The concept of, quote, necessaries is today equivalent to the concept of what Justice Lambert in the Queen and Vanderpeet 1993 citation, page 126, described as a, quote, moderate livelihood, end quote. Bare subsistence has thankfully receded over the last couple of centuries as an appropriate standard of life for Aboriginals and non-Aboriginals alike. A moderate livelihood includes such basics as, quote, food, clothing, and housing supplemented by a few amenities, end quote, but not the accumulation of wealth. In brackets, Gladstone, Supra, at paragraph 165, end bracket. It addresses day-to-day needs. This was the common intention in 1760. It is fair that it be given this interpretation today. Do you see that?
I do.
So Dr. Driben, you understand that where the Supreme Court is referring to moderate livelihood, it goes beyond mere subsistence, correct?
It does, yes. In the sense that subsistence is regarded as a bare subsistence. In anthropology, subsistence is not regarded as the bare subsistence. Subsistence is more a way of life.
Let me put it this way. So moderate livelihood addresses day-to-day needs, correct?
Here, I understand that to be, yes, yes, I understand.
Okay. And you say here, now in your happiness report, you put moderate livelihoods in quotation marks, correct?
Yes,
So, and when you put them in quotation marks, you mean moderate livelihood as articulated in the Marshall case, correct?
that's correct.
Now, we talked about day-to-day needs when we talked about Minnow-Bemadzewin in the Anishinaabe worldview. But let me just confirm, do you agree with me that Minnow-Bemadzewin requires day-to-day needs to be met?
It does, but we have to be careful when we talk about day-to-day needs in 1850 and day-to-day needs in 2023, because the day-to-day needs in 2023 are different certainly than they were in 1850. There's so many differences in life and so many different pressures on people that, well, like I said, the situation is different.
So some day-to-day needs can be satisfied through harvesting activities like hunting, trapping, fishing, gathering, correct?
That's correct, yes.
And you'd agree with me that Minnow-Bemadzewin is not about the accumulation of wealth, correct?
It's not about the accumulation of wealth per se, but wealth is necessary in order to achieve, or you never fully achieve Bemadzewin, but wealth is necessary, or material resources, I said, is necessary on the tobacco road, because when you look at the teachings of the grandfathers, as I said, you can see that generosity underlies all of the teachings. so that material resources are necessary to achieve to be on the tobacco road.
So Dr. Driben, I want to shift gears just a little bit and talk about the individualized nature of Minova Matsui, okay?
Yes,
So if we can turn to tab 20 of Exhibit K.
Yeah.
You'll find here page 79 of your happiness report.
yes,
And you'll see, Dr. Driben, that in footnote 221, there is a reference to an article by Lawrence W. Gross titled "The Madzwin or the Good Life as a Unifying Concept of Anishinaabe Religion," American Indian Culture and Research Journal, Volume 26, number 1, 2002. Do you see that?
I do.
And right after that, you have the word "passum,"
Yes,
and it's been a while since I've been in school. Can you confirm for me that "passum" means references throughout the article?
here and there throughout.
Here
Yes,
and there
correct.
throughout. Thank you. Now, we have a copy of the Gross article at the next tab of Exhibit K, tab 21. If we could turn there, please. Now, Your Honor, this is the place where I foreshadowed yesterday that there was a document in the joint book of documents where only the first page was included.
Mhm.
And here we have the full version. So what I propose to do is ask Dr. Driben a couple of questions about it and then mark it as the next numbered exhibit.
Right.
Just this time.
So I'll just, so it's in the joint book as 1567.
The first page is at Exhibit 1
Okay.
dash 1567.
All right.
So Dr. Driben, you've read this article, correct?
Yes, I have.
And this is the article cited at footnote 221 of your happiness report.
Among others, yes,
And this was among the documents we asked you to take a look at in advance of your cross-examination today, correct?
that's correct. Yes,
And you had a chance to look at it?
I did.
Okay. So, Your Honor, I'd like to mark this, this tab as exhibit number 18. And we might call it something like Lawrence W. Gross article titled "The Madzwin or the Good Life as a Unifying Concept of Anishinaabe Religion," dated 2002.
Yeah, that's good. Thank you.
Exhibit 18. Thank you.
And is there an intention to just thinking about hard copies? There's a, so you can imagine there's a repository of hard copies of the exhibits. Is there a intention to add to that with Exhibit 18? We can take it out of one of these books. if you want.
Yes, Your Honor. So our intention was actually to have a clean copy to mark in hard
Oh.
copy, but we learned this morning that we had the slowest printer on earth. So we were unable to.
Impossible. I can beat you on that.
Perhaps, Your Honor. So we can certainly have a clean copy
Next time.
delivered to the court.
Beautiful. Thank you.
So Dr. Driben, are you at tab 21 of the of Exhibit K?
Yes, I am.
Okay. And do you see at the bottom of the first page of the article, there's a description of Lawrence W. Gross at the very bottom. Do you see that?
I do.
And you see how it says that Lawrence W. Gross is an assistant professor at Iowa State University with the joint appointment in religious studies and American Indian studies. Do you see that?
Yes,
And you also see that Professor Gross is an enrolled member of the White Earth Chippewa Nation of Minnesota. You see that?
he is an Anishinaabe.
So if we can turn then to page 19. Do you see, Dr. Driben, in the third full paragraph? About halfway through, it says Bemadzewin, however, does not exist as a definitive body of law. Do you see that?
I do.
So it says Bemadzewin, however, does not exist as a definitive body of law. Instead, it is left up to the individual to develop an understanding of Bemadzewin through careful attention to the teaching wherever it can be found. This makes the term quite complex, and it can serve as a religious blessing, moral teaching, value system, and life goal. Do you see that?
I do. Yes.
And where Professor Gross refers to Bemadzewin, that's the same as Minnow Bemadzewin in your report, correct?
Yes, there are various spellings of it. Sometimes the tobacco road is referred to as Pimadzewin with a P. It depends on the dialect of Anishinaabe.
Okay. But what I'm getting at is where Professor Gross refers to Bemadzewin, that's the concept you're referring to in your report as Minnow Bemadzewin.
That's correct. Yes.
And the passage I just read to you from Professor Gross's article, do you agree with that statement?
Yes, I agree with it, because the idea of leaving things up to the individual is how that's how Anishinaabe society, that's how you learn in Anishinaabe society. In my happiness report, I discussed the child rearing practices of Anishinaabe, and child rearing practices are non-interference. They're based on non-interference. So the child explores, the child learns by its experiential learning. And I think that's what Dr. Gross is speaking of here. You may go up a path, and that may be a false path, but then you try another, so that you're always learning by experience. And you're going to be, as I said in my essay too on happiness, it's not a straight path. It's circular, because your life is ebbs and flows, and different contingencies occur. And so Minnow Bemadzewin can be a value system sometime. It can be, as he says, we could write it as a moral teaching, a code of life for different, during the quest, as I understand the quest from my teachers, it's an individual pursuit that benefits the collective, because when the person's on the tobacco road, then the community is strengthened.
Dr. Driben, could we move over to page 26 of the Gross article, please?
Sure.
Dr. Driben, do you see in the first, well, the top of the page where it starts, since the Anishinaabe do not have a set of commandments, do you see that?
That's, yes. May I comment on that for a moment?
You certainly can. I'm intending to read the entire highlighted section.
Oh,
If you'd like
sir,
me to
go
do
ahead, and
that,
then
then-
certainly go ahead.
Since the Anishinaabe do not have a set of commandments as in the Judeo-Christian tradition, or a set of recommendations as in the Eightfold Path of Buddhism, the teaching of the proper conduct of life among the Anishinaabe tends to be impressionistic, acquired through the telling of stories, most especially those related to the teacher's own life. And you wanted to make a comment?
Yes, I wanted to say that when we look at the 10 Commandments, those are thou shalt not. The instructions in Anishinaabe, the Anishinaabe instructions are you should do this. Not that you shouldn't do this, but you should do this. That's the comment I want to make already for a question.
All right, so let me ask you my question then. The passage I just read out, do you agree with that statement?
Partly, I mean, I take it that that there is a path. It may not be the Eightfold Path of Buddhism, but is following the teachings of the seven grandfathers, I think, is a path to Bemadzewin, certainly, and it is acquired through storytelling. And so I would agree in that sense as well, because you tell the story of how the way it works is this: in the winter, when these stories are told, the children listen to the stories, and they learn from the stories, from sacred tales, let us say, religious stories. Let's say what they are: religious stories that talk about proper conduct, the way to behave, the way to interact with others, the way to interact with the environment. And you do learn those through stories. That's their principal method of teaching, is through storytelling. And the Seven Grandfathers are one of the most famous stories of all, known widely.
Dr. Driben, can we turn to page 27 of the article?
Sure.
Do you see about halfway down, there's a discussion of Winnoa LaDuke?
Yes,
Are you familiar with Winnoa LaDuke?
yes, I
She's
am familiar
Anishinaabe,
with her.
correct? She's Anishinaabe?
Yes, she was at Lakehead University when I was teaching there.
Now, do you see in the same paragraph here where it starts, following Anishinaabe tradition, however, she refrains? Do you see that?
I do.
And I'm going to read this, but before I do, she here is referring to Winnoa LaDuke, correct?
Yes,
So it says, following Anishinaabe tradition, however, she refrains from providing an exact definition of the good life. Instead, she offers examples of living individuals who survive primarily by following the traditional practices of hunting, fishing, gathering wild rice, and making maple syrup.
I do.
For LaDuke, then Bemadzewin means living in harmony with the natural cycles of life in the North Woods of Minnesota, thus stressing that aspect of the good life marked by environmental morality. Do you see that?
I do.
Is that consistent with your understanding of Bemadzewin?
Well, for LaDuke, it is, and I understand what she means here. And what she says is living in harmony with nature, realizing that there are two categories of persons. There are human persons and there are other than human persons. Those other than human persons can be water, they can be animals, they can be rocks. That's the world Anishinaabe live in. They're filled with spirits. And what she's saying is that if you're in tune with the natural cycles of the environment, then you're on the path. Then that's a way of achieving the good life. But you could say the same thing about the teachings of the Seven Grandfathers, because the teachings of the Seven Grandfathers will result in you living a life in the bush that does exactly what LaDuke says, which means living in harmony with the persons and non-human persons who occupy the environment and the spirits that are there as well.
So, Dr. Driben, just now, I believe you said that this would define Bemadzewin for Ms. LaDuke. Do I take you to mean that the concept of Minnow Bemadzewin may mean something different to individual people?
No, I think it means the same to Anishinaabe. I mean, Anishinaabe understand it as a underlying principle, as Dr. Gross said in the previous article we referred to, as a unifying concept in Anishinaabe theology. And I agree with that. Dr. LaDuke's take on it, I understand that as well. Because to me, if you listen to the teachings of the Seven Grandfathers, if you're a child growing up and you're in the house and you can see it, you can see the fire, burning, you can see the kids and you can see the old people, the elders. And this is not only your entertainment, this is your education. And if you tell the teachings of the Seven Grandfathers to the children, it's exciting, because remember, we're living in an 1850 world, or maybe we're living in a 1920 world where there's no TV, a little bit of radio. Then if you follow those teachings, you will do exactly what LaDuke says. You'll interact with the environment as part of the environment. So I don't think she's saying anything really different than I'm saying. She's not saying, no, it's not the seven grandfathers teaching. I think that, I don't know because I haven't raised the question with Dr. Leduc, but maybe she would agree with me that if you follow the principles of the seven grandfathers, you'll achieve exactly what she says.
Let me put it to you this way, Dr. Driben, would you agree with me that there is a diversity of views on Minnow-Bemadzwin within
Yes,
Anishinaabe culture?
Sure, it's expressed in different ways by different scholars. I understand that, but again, I want to come back to the point that it is a unifying concept in Anishinaabe theology. It's the reason why people are here, the reason why Anishinaabe are here, to achieve Minnow-Bemadzwin. That's rock solid.
Would you agree with me that Minnow-Bemadzwin does not define fixed perspectives on sharing?
I think it requires generosity, but it doesn't say anything about percentages. You're as generous as you can possibly be if you're on the tobacco road, for sure.
Your Honor, can you just give me one quick moment? So, Dr. Driben, I just have one final thing, and that's to thank you for your engagement. It was much pleasure on my part to engage with you on this, and Your Honor, this concludes the examination, cross-examination of Ontario.
Thank you very much.
May I say you're welcome and thank you.
Thank you.
Your Honor, could we have a 15-minute recess to consult with our team members online?
Sure.
Thank you.
Piers, my watch has stopped. Do you want to take lunch then and come back for?
Well, I don't know that we need to.
Oh.
I don't know that we need, we're not gonna need that much time.
Okay.
I do have something that I would like to excuse the witness for, and while we're breaking on just before the break, perhaps we can excuse the witness and I can address it.
Before Canada takes a chance to.
Yeah, I mean, I could wait until after, but whatever the courts, there's
All right, so
something
there's
has
two.
come up that I would like to address the court in the absence of the witness.
Okay, so there's two things we need. How much time do you need, Ms. Sang?
15 minutes should be good.
Okay, so should we do your issue first, then take a 15-minute break?
Yes, yes.
Okay, thank you very much. Sir, can you find a place for a smoke or something? I don't know if on this floor there is another room. Oh,
Well, maybe he can go up to our room. Should I give him the key? He can be
Okay.
escorted up to,
very good.
you know where it is. Yep.
Thank you. Go ahead.
Um, The only time that I would do a redirect if there was confusion, and I'm not sure that there was confusion or not, and I wanted to be candid with my friend. Dr. Driben spent a fair bit of his report talking about an annuity is not akin to a moderate livelihood, and it's more than day-to-day needs. And my friend, during the cross-examination, asked him, you would need day-to-day needs. But he didn't ask him the obvious follow-up question, do you need more than that? And it just seemed to me that, I mean, rather than me just arguing that, it doesn't serve anyone to be vague about what's left on the record. And either I could do it indirect or the court could do it. I don't know if anyone else is troubled about that, but it just doesn't seem to me that it was the kind of admission that my friend probably thinks, but it maybe would be an admission or maybe not. And I'm not sure how to deal with it. That's why I didn't want to deal with it with the witness here. I just think it's important that, people do their best. And I thought there was confusion there about whether he had made an admission that you only need day-to-day, the day-to-day needs, or if my friend thinks that that's the admission he got, because I don't think he did, but I don't know how we want to deal with that.
Do you want to respond, Mr. Rankin?
Yes, Your Honor. So I can't tell my friend how to do the redirect. But what I will say is that the emissions that are on the record are the emissions that are on the record. Dr. Driben's report is also in the record. We have that evidence already. And from my perspective, the cross-examination is concluded. And the record is what it is. And my friend thinks that something needs to be addressed in redirect. That's his right to do so with a proper open-ended question.
What I thought was just going on was Mr. Schachter was alerting us to a question he thought he would ask, but was giving you a chance to object first. Is that partly what was going on?
Does Manitoba management require more than meeting day-to-day needs?
Right.
Well,
So I think that's all he was doing, so the witness was out of the room.
fair enough, Your Honor. I mean, I might say on a technical point that would be a leading question. So I might have, given the opportunity to object proactively, I might say that it might be reframed in a non-leading fashion, but other than that, if that would be a proper subject matter for a redirect, certainly.
Well, presumably the foundation would be put to the witness for the proper redirect.
Sure.
You were asked this, gave this answer. Follow-up question is, and he was just, I think, tell me if I'm wrong, give you the chance to object. You say you would object that it's leading, but if there's a foundation set, do you have any problem with that?
With laying a foundation, certainly not, Your Honor.
Okay, and does anyone else want to weigh in on this? Mr. Gober, no. Canada, no. Okay. I'm always of the view that we should get the record as clear as possible, so I don't have a problem with that question. Okay, so so you're going to save that for redirect. Canada, you need 15 minutes. All right. Let's take that now. Thank you.
This court will recess for 15 minutes, returning at 12:35. Thank you. This court is now resumed. You may be seated. Thank you.
Get on the screen.
Your Honor, your Canada has no further questions.
Thank you very much. Let me just whenever you're ready, Mr. Shaw.
Dr. Driben, I just have a couple clarifying questions for you.
Sure.
In the cross-examination, you were taken to tab 17, which is part of your report. And I wonder if you could go there for a moment.
Sure.
It was at page 83 of your report where my friend. took
Sorry, are we in the Exhibit J?
Exhibit J, I believe, yes.
Okay,
K,
okay,
Exhibit
sorry.
K.
Tab,
Thank you. Tab 17.
thank you.
My friend took you to page 83 of your happiness report,
That's correct.
and he read out to you the following. 2 additional points about the quest for Minobamadzwin deserve mention. The first is that the emotional, physical, mental, and spiritual health that is acquired during the quest for Minabemazwin requires adequate material resources to be acquired. Otherwise, those seeking Minabemazwin almost certainly will be distracted by subsistence levels. And my friend, I believe you answered that you made reference to your coda,
Yes,
and the coda is where the elephant in the room is. That's that.
that's
section.
correct.
And when you were referring to the coda, those are the benefits that the Court of Appeal had talked about, or the income gap and the like. I think you even mentioned the income gap.
I did, yes, and the education gap and others.
Yes. Now, the subsistence, being distracted by subsistence demands, you then gave evidence to my friend that subsistence demands is the day-to-day demands.
Yes,
And he also, and you agreed with him, that the day-to-day demands is the day-to-day, well, let me use the words of day-to-day needs, not demands. The day-to-day needs
yes,
is equivalent to a moderate livelihood. That's, I understood your evidence to be that day-to-day needs is the same thing as a moderate livelihood.
no, no. The day-to-day needs could be mental health today. It could be that have to do with education. The day-to-day needs today are different than they were in 1850. Not the same. There's many more needs today than there were in 1850, I imagine.
The question was put to you, does Minabemazwin, sorry. The question was put to you, but just let me confirm, do you agree that Minabemazwin requires day-to-day needs to be met?
Yes, it does, certainly.
Does it require anything else?
It requires what the Anishinaabe say it requires to achieve Bemazwin. They're the ones that determine what's needed, and they will be the ones that determine that on the basis of the contingencies in the environment that they face at any particular time. So what it takes to achieve minimum Bemazwin, the day-to-day needs that are required in 2023 would be different than they were in 1993, and they'll be different than they are in 2053. They're evolving, they change.
But is there any difference between moderate livelihood? I'm a little bit confused. Perhaps you can explain to the court how day-to-day needs, which is moderate livelihood, like, sorry, I understood, and I'm gonna maybe try this again. I understood your evidence to be, in, perhaps Ms. Lewis can find it in the transcript, where you had agreed that moderate livelihood means addressing day-to-day needs.
Yes, yes.
I also read in your report that the annuity is not akin to a moderate livelihood. It's not akin to day-to-day needs.
That's
So
correct.
you'll have to square that for me, because it either is or it isn't. I don't understand, and you need to explain to the court what you mean by the annuity is not akin to a moderate livelihood, if in fact moderate livelihood is day-to-day needs, and day-to-day needs is what you need for Minabemazwin. I'm confused.
I was thinking of the term subsistence in terms of foraging at this particular time. If all day-to-day needs must be met in order to achieve Bemazwin, they must be.
Yeah, but is that all that's needed?
No, there's other things that are needed to achieve Bemazwin as well. You need teachers, you need support from communities, you need all other things to achieve Bemazwin.
And do you?
And that includes day-to-day needs for sure.
Okay. I think I understand now. Thank you. I don't have any more questions.
Thank you. Right. I have no further questions. So I think you're excused. Thank you very much for being here and participating in this process in this way.
You're welcome. It's been a privilege.
Thank you. All right, we're off the record.